I'd like to introduce Justice Benjamin Barnes. He's a 1st District Court Justice of Malden, the Malden Division of the District Court. He's a Fisk University graduate and a Suffolk Law University graduate, so he's brilliant. I haven't just gone to Suffolk undergrad, but he also was an assistant DA, so significant trial experience, and a clerk magistrate before his appointment in 2009 by Paul Patrick. So I'd like to just give a warm welcome. And I'd also like to introduce the clerk magistrate, MARYBETH Brady of Malden District Court. She's been involved in Massachusetts judicial system for over 30 years and has been described as a consummate, dedicated public servant, and she's a personal friend of mine. She was appointed by Governor Deval Patrick, for the Malden District Court clerk position, which is significant, and I'd like to welcome her also. Now we have a fairly open agenda today. The Justice and Clerk will, give some opening comments, whoever would like to go first, but this is about you today and communicating some information about what they do and how it might impact you. It's a great opportunity for you if you have any questions about the judicial system to ask. I have some questions that I have, and I might hand them out to you, and maybe you could ask them or come up with your own questions. And we have a microphone here, and maybe I'll, at the end, or however you want to proceed, I can help with the questions as we go. So, without further ado, I'd like to present the panel.
All right, thank you. Just try to use my radio. First, can everyone hear me?
Yeah.
Well, good morning. I want to thank you for inviting us to be here today. It is always a pleasure to meet young people going out into the world. I understand a lot of seniors in the room. Yeah, so you are definitely our future. So thank you for your invitation. And it's always good to meet a judge when she does not have their robe on. That's when you know you're going to have a good conversation. So take advantage of that. And my goal today is just briefly go into what we do in Malden. And then kind of open it up for questions. I got a sample of some questions that were very good, and I'll try to address some of those and then open it up to the audience. But just for a show of hands, how many have taken the criminal justice course? Okay, excellent, excellent. So I'm going to do a couple of topics on criminal justice, and then we can open it up to anything else after we hear from the clerk magistrate. Just want to show of hands. Does anyone know what a clerk magistrate does? It's clouded in mystery. I didn't know what they did until I became one. So she will cover.
They do everything, right?
Yes, they actually run the courthouse. So it's a lot more powerful than the judge, but it's a secret. So Malden District Court. So the Malden District Court, we handle the communities of Malden, Everett, Melrose, and Wakefield. So what that means, that is our jurisdiction. So any crimes or any victims or anyone who lives in those communities, their court venue will be the Malden District Court. So those are the 4 communities that we handle. Predominantly we do about, I would say close to 70% of our work is criminal in nature, but we do both civil and criminal hearings in the Malden District Court. We do not do any juvenile matters, but just adult criminal and civil matters. And civil matters including restraining orders. So, I've been a judge for 10 years now. Grew up here in Massachusetts, in Cambridge. Went to Cambridge Public High School, a lot different than this high school, but we were also called the Warriors. So go Warriors, and then we had to change our names. I don't know if that's on coming for you guys, but that happened to us. But Malden District Court on a criminal matter. So if someone gets arrested, not anyone in this room, in Wakefield, they will go to the Malden District Court. What happens as soon as someone gets arrested by a police officer? What's the next step? Other than putting handcuffs on? The first part of the criminal justice system is the...
You gotta read them their rights.
Oh, okay. Good.
You gotta do that, like, while you put the handcuffs on them.
All right. You generally want your rights known before you put your handcuffs, but okay. All right, what are those rights called?
Miranda.
And why are they called Miranda rights? Anyone know? So most rights, oh, here we go.
The Miranda case.
The Miranda decision, yes. Yeah, absolutely, gold star for Michaela. All right, yes. So it's named after the individual who sued and said that I had no idea that I had all these rights before they arrested me. And that case went to the U.S. Supreme Court and said, yes, now if anyone gets arrested, these are the information you need to share with them. So they read their Miranda rights, and let's say everything's fine, they're brought to the police station, and they're given what opportunity now at the police station? Question of bail? No, never heard of bail? All right, so they're arrested. So,
They're a little shy today.
okay. So in Massachusetts, we just don't hold people. We give them the opportunity. That's what they say. I want my one phone call. You see that in the movies all the time. But you know, they do give you an opportunity to call someone and say, I just got arrested, and the bail is, and the bail can be set. So at nighttime, this is when the clerk magistrate's position is so valuable, because they're not calling the judge at 2 o'clock in the morning and say, you know, what's the bail? They're calling the clerk's office. So at nighttime and on the weekends, when the court is closed, the clerk's office or someone from the clerk's office, or a bail commissioner or clerk magistrate sets bail. So they will say, based on your record and the incident, we're going to set bail at $200. And then that's when that person makes the phone call and tries to get their friends and family to come up with the money. So if they come up with the $200, they get released to show up in court the next day. If they do not come up with the money, they stay in jail. So if it's on the weekend, you stay in there Friday night, Saturday night, Sunday, show up to court on Monday, if you do not make bail. And then once they're in the courtroom, you have what's called the arraignment. Does everyone know what the arraignment is? Once people be saying yes. So that's when we get involved, or my colleagues get involved at the arraignment. So this is someone we know that bail was set, they could not make it, but then there's a whole new question of bail in front of the judge. So the clerk's number either stays, goes away, the judge makes a decision once they're in front of the judge. So that's the way to get the case into the court. So that's the first thing when someone's in front of us for arraignment. That's what happens there. And the criminal justice system, based on, I was told you watched the movie 12 Angry Men. That one, people seen it? Now what was some of the, I would say, themes from that movie that relates to the criminal justice system? Question and answer.
Take a stab. Go ahead, Mark.
Conflict, yeah, conflict between the jurors, yeah, absolutely. Conflict in what people had of their preconceived notions of individuals. That's something called bias or implicit bias. And that is, the jury system is a reflection of the criminal justice system. So what our job in the criminal justice system is to find a way to filter out that bias, that implicit bias, or any stereotypes or any notion, particularly when it comes to individuals' rights. So we don't want to have someone in front of the court and say, oh, they look a certain way, or they act in a certain way, or I just think, you know, they're not going to show up. And my bias comes into making a decision on that person. So that's what we try to eliminate in our criminal justice system. We don't want that bias to come in like they talked about in the movies. And how do we do that? We try to be fair and objective and keep an open mind. So once the person is in front of the court, we are not an advocate either for the police department or for the defendant. Our role is to be neutral. And that's what's important about our criminal justice system. We as judges and clerk magistrates are supposed to be neutral. And when we are neutral, that's when we have the best possible outcome. It's when the judges or the clerk tend to be advocates for the police, or in organization like public school education, that's when the system seems not to work as well. For example, I've noticed everyone in the school has a locker, correct? Some have locks on it, some don't have locks on it. Do you think that the police will have a right to search your locker in the Wakefield school? Based on what you have heard about the criminal justice class. Could a police officer just walk in and say, I want to look in locker 385?
Why?
Do you think they have a right to do it for no reason? They just want to walk up and look at it?
No.
What do you think?
I mean, like, because it's a school, like, they might say, like, school grounds, they can search whatever it is, but, like, as of, like, it's my locker and you have no intent, no.
Because you have a right of what? Illegal searches and seizures under the Fourth Amendment, you believe?
Yeah.
Right. So you would think the police will they will need a reason to search?
Yeah.
Okay, we got another theory?
I was gonna say
A reasonable suspicion to search your locker. Okay. How about your history teacher? Could your history teacher just walk up and say, you know what, I want to look at your locker? What do people think? Well, these are your rights, students.
no.
No. Okay, someone said no. Why would not the history teacher have a right to just go through your locker?
Because unless they have a reason.
So they need a reason to.
Yeah.
Okay. All right.
Okay,
Does
do
everyone-
you lose your civil rights when you come here?
Good.
Do you lose your civil rights? Yes.
Yes.
I heard a yes and a no. Let's go with the yes. Do you lose all of them, some of them, or
Or are they
Like
limited?
80%.
They're limited.
limited? Okay, and who feels you do not lose your civil rights when you walk through that front door?
Okay, take a risk. Take an answer. Think about what you've learned and then make an answer. So, do you have all of your constitutional rights when you come to school, or are they limited? Or do you have none? What do you think?
Someone said 80%.
Yeah, 80%.
That's a good one.
Okay, they're limited, right? They're limited.
Stop and frisk if you're going to the bathroom.
Well, that's different than, we're gonna stick with the locker room. We're gonna stick with the locker. So, your history teacher would not need any reasonable suspicion to search your locker. You have given up your rights based on what the law says. As a student, you're in the care and custody of the school. So they could walk up anytime, and they probably, without you even noticing, beginning of the school year, had you sign a bunch of papers, and one of those says, you don't have a right to what's inside that locker. That is property of the school. They're letting you use it. That is their property. And there is no expectation of privacy of what's in that locker. So unreasonable search and seizures goes to individual spaces in which there's an expectation of privacy. And the courts have ruled that students, like yourself, they know they're just using those lockers. They're not gonna put their weed in there. There's no expectation of privacy. So you can go and take a look at it at any time. However, the police officer may need reasonable suspicion if he's investigating a crime. But if he's doing it at the request of the history teacher, he would not. And that's why you have school resource officers in the building. So sometimes the history teacher will go up to the school resource office and say, hey, take a look at that locker. And if he's just doing it at their request, you have less expectation of privacy. So that's why it's very important that you as citizens who are now coming to voting age know what your rights are and what they are not, and what location they are. The most expectation of privacy that we have based on our constitutional rights is in our home. That's where we have the most rights. The least rights you'll have is in the schools or on the public way.
Judge, what about your backpack?
Good question. I want to go back to the search on the way to the bathroom, though. So, and this will lead into the backpack. The history teacher and the police officer would not have a right to search, and that's your person. We all have an expectation of rights things on our person. So they will need a reasonable, articulable facts to say, I want to search that individual, or pat him down, sometimes called the Terry frisk, named after the case the Terry case. Yeah, Terry, Ohio. So that's what, now they just shorten it to be the Terry pat frisk, which gives you the right to pat the outside of your body. And generally they say, well, I just saw a big bulge, so I wanted to frisk it. Make sure it wasn't a weapon. Your backpack, if it's on your back, it will be considered part of that frisk. But if you're standing here and your backpack is over there, there's a different issue, because that's not on your person. So if that backpack is in that chair, and the history teacher wants to go through that backpack, who thinks that he or she would have a right to do that? Without any reason.
So could the history teacher just open up, come over here, and I want to search your backpack? I'll say, hey, can I search your backpack? What are you going to say? No, I can't? Okay. Can I search your backpack? What if I think there's, you have some drugs in it? Well, you know, I'm sure you don't, Tim. Like, I want to search it just to make sure, just to clear your name. Can't I just search it to clear your name? If there's nothing in there, what are you afraid of? Okay, so could I search that bag? What do you think? Yeah. You have first Fourth Amendment protection in that, right?
I didn't hear you, I'm sorry.
You have to be touching it, or does it have to be on your back, like a backpack, or?
It has to, well, depends. So if they want to search and it's on your back, on you, they will need some sort of reasonable suspicion that there's something illegal in that bag, because it's on your person. If it's, as the teacher said, it's over there, they will have less of a standard. Because again, that's a bag, you're on school grounds, and the law has indicated that safety of everyone reduces your rights as an individual. Because we don't want individuals walking in school with weapons, and we don't have x-ray vision, so if the bag's over there and you're not around it, and you say, hey, I'm just going to take a look at your bag, just to make sure that everyone else is safe. So your rights have been reduced as you walk through the door.
Absolutely correct, Your Honor. So in school, your rights are reduced. They need a reasonable articulate suspicion of criminal activity before a search can be made in school. Once you go outside, though, it pops back up to what? Before you can do a search, come on. Probable cause. They would need probable cause and what? A warrant or a warrant exception before they can search.
Right. And that's what we deal with all the time in court. Someone feels that they were driving Main Street in Wakefield, pulled over, police searched the trunk, find a pound of weed in the trunk, and they say, hey, that was an illegal search. You didn't have a right to do that. So we have those hearings all the time. Now, the Fourth Amendment protects us against unreasonable search and seizures. Doesn't say all searches. It has to be an unreasonable search and seizure. But what is that based on? Why did we come up with that theory as a nation of illegal, a Fourth Amendment?
Think back to when the Fourth Amendment was adopted into the Constitution. What were the reasons for that?
What was the reason?
Things happened.
Cake?
Cake, Marcos, cake.
Wasn't it because there was a lot of British soldiers going in?
Correct. So the British soldiers at the time, they were the police. So the British soldiers could kick in your door and just say, hey, I'm just searching. And they want to eat your dinner on the table, they can do that too. So once we had the revolution, we said we want some rights. We're afraid of, the police breaking in our house and kicking in our door for no reason. We already went through that. We're not going to have that again. So that's what they came up with, the plan of illegal search and seizures. But it was based on the fact that the British were the police and they were trampling over their rights. Everyone understand that? So now we have the police officers or state action have taken that place.
Judge, what about your cell phone?
Ooh, that's a good one. The cell phone, which I'm sure everyone has.
Wasn't contemplated in the Constitution, or was it? Persons, your Fourth Amendment protects what? Houses, persons, papers, and effects. What do you think about that? Is your phone like your backpack, or is your phone something else. What do you think?
Cell phone.
What's the difference of like, you get the phone, but like, you don't get my password, so like, there you go.
Well, I just had a case in front of me last week. The district attorney's office, everyone knows the district attorney are the people who prosecute the cases. And then the defense counsel represents the defendant. Cell phone, picked up on a drug matter, he said the same thing. Well, I'll give you my phone, you have my password. They requested a court order for that person to give up their password so they could see what's inside their cell phone. We had a hearing on whether or not that was constitutional. Did they violate that person's right to force him or her to give up their password in order for the police to get into the phone?
How is that ruled on? I don't think you mentioned that.
Still under advisement.
Okay.
Who thinks we should order someone to give up their?
Okay, so crime is committed, the police are, I'm assuming, alleging that there's some...
Yep, there's information about that crime on the phone. And they said, you know what? You gotta give up you gotta give up your combo.
That's
so
like
you can
taking
see.
a shortcut. Like, you gotta find your own evidence, don't go taking their phone, you know?
No. Well, good point, good point. So the government's theory is this, allegedly, this is all hypothetical, that the person was involved in drug trafficking. They have phone numbers that they use as a undercover to call a specific number, that person's cell phone. So and to buy and transfer drugs. So if that phone number appears and they send information to that phone, then that will be evidence that that person was involved in this prearranged sale. So they want that, so they already seized the phone, they can't get into it, so they want to find evidence. So they have a good faith belief that there's evidence in it. So they're not just, searching, because they sent it, so they know what they're looking for. So that will connect this person to the crime. But the individual said, well, I have my rights. You don't have any right to go through my phone, my personal papers, because that would be an illegal search of my personal papers. There's no difference between you, my phone keeps my files. You wouldn't be able to go through my house and take all my files. Why would you be able to do it just because it's on the phone? That's mobile. So those are the two countervailing arguments.
Can you get a warrant?
So they already got the warrant for the phone. So it's in their custody. The phone is sitting at the police station. So they got the warrant for the phone, but now they need to get into the phone. So that wouldn't be a warrant. That would be a court order for this individual to say, okay, put in your password.
So now the prosecution would make an argument, and then the defense will make an argument. So I'm going to make the prosecution argument, if you don't mind, Your Honor.
Absolutely.
Hypothetically. And then I want someone, maybe Mr. O'Brien or some of one of you can make the defense argument, okay? Your Honor, Barry Fitzgerald for the defendant, for the prosecution today. I would like to bring the Justice's attention to the seized phone. And Your Honor, we can understand, we can all look at the phone, but that's not why we seized the phone. The warrant was for the material associated with the phone. This phone is just like a desk. I'm looking for the key to the desk. I suppose I could break the desk, Your Honor, but that would be such a waste. I would put to you, the court, that the password is a key to a desk, and so we would like Your Honor to make the defendant turn over that key. Okay, let's hear from the defendant. Why should they get that?
It's simple. Just turn over your keys. No big deal. What's the other argument against it? Wow.
Come on, we gotta...
We won't have you guys be criminal defense attorneys. But it's not, to this question, I think of it, it's not a Fifth Amendment issue because those are not statements. Fifth Amendment goes to statements. So your statements cannot be used against you.
But Your Honor, to please the court,
It pleases.
by giving up my password, right, I'm essentially releasing statements of sorts.
How?
Because
Statements are testimonial in
you
nature.
can access evidence that's potentially going to incriminate me. So I would argue that you're one step removed from a statement that's essentially self-incriminating.
Okay. Very good argument. But the courts have said that is not a statement of you to give up your password. It's not testimony in nature. It's very similar to, this is the analogy, when the police pull you over, not you guys, when the police pull someone over and they say, we want you to do field sobriety test. And you can either say, yes, I'll do it, or no, I'll do it, but if the officer asks you to do the field sobriety test, and you choose not to do that, the officer can testify, and they do, what you did on the test, and they can testify whether you did it correctly or not correctly. And people say, well, that's incriminating. You're self-incrimination. They've said, that is not a statement. You performing those tests are not a statement.
So how are they gonna force me to give up my passport?
That's a good question. So it has happened, and what they do, you are held, if it's a court order, then you are held in contempt. That means they hold you in custody until you can cleanse yourself of the contempt, and that would be by giving up the passport. So you cannot purposefully violate a court order. So that's why they're going in front to get the court order from the judge. So if the judge says, okay, yes, you have to do it, and you say, the hell with you, I'm not going to give it to you. Then you say, okay, you can go downstairs and it will hold you until you come up with it. So that would be the remedy. Whether that is a constitutional one, that's the question. But that would be the remedy. They will hold that individual in contempt until they can clean themselves of that contempt.
Is the Supreme Court ruled on forcing passports?
Our Supreme Court, the Massachusetts Supreme Court has not. The U.S. Supreme Court has. So we have in Massachusetts, how many knows Massachusetts has the oldest constitution? Yep, of all the states. So we have in our constitution, the Massachusetts Constitution, the Declaration of Rights. So we were so concerned about people trampling on our rights in Massachusetts, we added additional rights just for citizens in Massachusetts, and that's called the Declaration of Rights. So we could have rights in addition to what they say in the U.S. Constitution. So sometimes our state courts, which is called the Supreme Judicial Court, will add certain rights that other states won't have because of our own Constitution. So our Constitution could say it will be illegal to have someone give up their password.
And we happen to live in a great state because the Declaration of Rights gives you more protection
Absolutely.
than the U.S. Constitution. But if I could make just one quick argument, Mr. O'Brien, maybe to support what you're saying is, you know, the key to the phone is going to give you more information than I would assume the scope of the warrant. So who's in charge, being a gatekeeper, for the information that's subject to the warrant and not, so I would make an argument that it's too broad of a request, a key, that it's like, you know, having a warrant to seize a gun. When you find a gun in someone's house, you've got to stop. But with this request, once you find a number, it seems like you can keep looking for numbers and keep looking for those chain numbers, if you understand my argument. I think that the warrant may be too broad, and they need to have some more information. Warrants have to be very specific. Place to be searched and items to be seized. This is, I don't know, I might deny that. If they ever ask me, but they won't.
Okay? Yes.
So, if someone's being held because they've been ordered to give up their password, what happens if they're somehow, what if they've forgotten, or they're somehow incapable of actually giving you the password?
So that would be a hearing. The judge, will base it, the person can make a reasonable argument and say, well, Judge, I just forgot my password. I'm not intentionally ignoring the order. I have 15 different devices. I have no idea which one this is to. I can give you a couple. If they don't work, I think I just forgot it. So if they can convince a judge of that, then they wouldn't be held in contempt because they're not doing it intentionally. All right, so I don't want to monopolize my time. We'll come back to questions, but I know Magistrate had something to say.
I just have not much to say. As I said to the judge when I said I would come today, He's the lead singer and I'm the backup. But my position, again, I'm the clerk magistrate of the Malden District Court. I just celebrated my anniversary in the system. I became an assistant clerk 25 years ago, so I'm in the system 35 years now. I was in Suffolk Superior Criminal Court for 25 of those years before I was appointed by Governor Patrick in 2008, and it's a lifetime appointment as clerk magistrate. Some days I would say it's a life sentence, but I love what I do after all these years. In the district court, it's really where your connection to the community is so strong and so real, and the best part of my job is that every day I can have an impact, I and my staff can have an impact on people's lives, and it can be positive and negative, and my goal and that of my staff is to make whatever interaction with the community and the people that come to seek justice in our court as, I wouldn't say it's always pleasant, but that we can help them navigate through a system that they don't understand. Everyone that comes before the court, unless it's for an adoption, it's usually not for a good reason, whether it's a criminal matter that somebody's been arrested or a young person has been charged with minor in possession, and anything like that that's considered a misdemeanor. I'm sure you've probably studied about misdemeanors and felonies. So if someone is charged with a misdemeanor and they have not been arrested, they're entitled to a show cause hearing that would be conducted by myself or one of my assistant clerks. So in that situation, even though I don't wear a robe, as a clerk, you have a lot of discretion. You have a lot of what I would call adjudicatory powers, where myself and my clerks, we determine probable cause. When the police arrest somebody, it doesn't get to the judge until one of my clerks reviews it and makes sure that the police have met all of the elements of the crime, that there's enough probable cause to believe that this person that's going before the court has committed the crime, and then it's up to the jury later on. Proof beyond a reasonable doubt is a much different standard than the probable cause standard. So if you come before one of my clerks or myself, the purpose of that hearing, probable cause would be very easy to find, say in a situation of minor in possession, or bad judgment doesn't mean that you're a bad person and your future has to be impacted. So what we try to do in that room where I have discretion, on my clerk does, is we work with the police, and we don't want to ruin a life. So we might say, for the next 6 months, you need to do X, Y, and Z. You might maybe perform some community service if there's some destruction of someone's property. We want to make the victim of anything whole. That's the goal. Punishment is important sometimes, but there's also mercy, and I think that is the venue and the part of my job that I love the best, is that in that room I can change what is a bad situation, and maybe a positive will come of it. So another of our duties, every day is we approve those search warrants that the police are bringing. So when I was in the Superior Court, I used to sit and think, what was the clerk thinking of? There was no probable cause. So the first time that I had to do a search warrant as a clerk magistrate, I felt like a deer in the headlights, making sure that every I was crossed and every T was done, and that the police, there was enough evidence there, and it was timely, it wasn't stale evidence. So every day we do those search warrants. If a judge is not available, the clerks, during the session of the court, if the judge is not available for a conference, the clerks can set bail. And then, as the judge said, in the middle of the night or on the weekends, because of a Jenkins case, somebody is, they should be admitted to bail within 24 hours of their arrest. So the police will contact my clerks, and we set a bail, and then they'll come before a judge, and the judge will either uphold it or change the bail. I always say, in the clerk's office, we're the keeper of the record, and everything begins with us and it ends with us. So whether it's a civil case or a criminal case, it all has to start in the back of the house, as I call it. In my staff, they have to make sure that everything is properly processed, and that it's affecting somebody's livelihood, it's affecting somebody's life. And something as simple as a license. Someone's license is a lot of times their livelihood. So we have to make sure that we get everything right every day. It's a lot of responsibility, but I think I have a wonderful staff, and they're up to the challenge. And I would say to any administrator in the trial court, the biggest part of my job every day is how we treat the people that come before the court. we are by and large public servants, and that's, I say to my staff all the time, nobody wants to be ignored. When they come to the office, you need to acknowledge them. Even if you're busy, just say, somebody will be right with you. And nobody wants to be, waiting there and having everybody's head down, and waiting somebody out. Oh, they'll take care of them. So I think, we, as a court, and I think our reputation has gotten pretty good. Sometimes people will say to me, geez, your staff is wonderful. 5 people asked me if I was all right. That, for me, as the manager, is music to my ears. But, so that's just a little overview of my responsibilities as the clerk. I don't know if anyone has any questions about my job. Okay.
Well, first of all, let's have... I noticed some hands in the air, and we have about maybe about 8 minutes for questions. So let's hear some questions. Okay. So my class might have a few. What do you think? Go ahead. You can stand up. Want to stand up and nice and loud. Go ahead. Stand up.
What is one thing you would like defendants who appear before you to know about you or the trial process?
So the question is, what is one thing that maybe the justice or the court would like to let the defendants know when they come to court about the process?
Be on time is very important. For me as a judge, when the defendants are late or don't show up, be on time, and just the same things I would think that you would use those same skills if you're in front of the principal. Be on time, don't chew gum, definitely don't talk back, and listen to your lawyer.
And be respectful of the process.
Yes.
And dress appropriately. Yes, good.
Do you see a correlation between drugs and/or alcohol and criminal activity? If so, what do you think about the recent trend to legalize marijuana?
Yeah, I did see that as a question. There's definitely a correlation between drugs, alcohol, and criminal activity, but there's more of a correlation between education level and criminal activity. 60% of everyone who is currently incarcerated in Massachusetts does not have a high school degree. 80% of people currently incarcerated in Massachusetts do not have a college degree. So we're not saying that you're less likely to be incarcerated. What we are saying is that individuals who are now incarcerated have lack of opportunities, which education brings, that lead to other destructive criminal nature. So how do you prevent that on your own? One is by doing what you're doing now, getting to high school, and then 2, further on, whether it's vocational or college, that significantly reduces based on the stats that we have. So that has a big correlation. But we do have a drug court in Malden, and our theory is to rehabilitate instead of incarcerate, and our drug court deals with individuals from those communities. With the legalization of marijuana, what day does that become legal in the state of Massachusetts?
Isn't it like June 1st?
Ooh, well, from him, the guy, he knows when it's legal. Okay, yes, absolutely right. It's actually July 1st. July 1st. But I do not want everyone to bring all the weed to school, start puffing on your way in, because they have the ability. All communities have a right to put the location, time, and area where you can enjoy your now legal cannabis. So one of those locations, I'm sure, will not be your homeroom class. So just because on July 1st it says, okay, it's legal, there are still limitations, just like with alcohol and with cigarettes. So be conscious of that. What it really means is that you won't be able to get arrested. There will still be sanctions, civil sanctions, and I'm sure some school penalty sanctions. I don't know whether the legalization of marijuana is going to be an increase in crime. A lot of people are saying that. A lot of people are saying no, it won't. I have no idea. I do know in Colorado, where they have been doing it for about 3 years now, there has not been any increase in crime. In fact, violent crimes have gone down in the state of Colorado for violence. And they said the number of arrests at the Denver Bronco games have gone down by over half. Because those individuals, I'm assuming, used to drink alcohol, now maybe smoking weed, and they're not getting in so much violence. That's just at the football game. I know they had stats on that.
Okay, another question? Any other questions? Annabelle, do you have a question?
I have to respond to this question before I leave. Elected judges, I'm totally against. I don't think judges should be elected. Massachusetts is one of the states where you are appointed by the governor, and if you're appointed as the clerk magistrate, it's for life. Judges have to retire at 70. Not because it's in my personal interest, I just don't think if I'm sitting on a case, let's say for the case we've been discussing about cell phones, if I got $1 million for my campaign from the cell phone industry, I think my decision would be kind of tainted on how we're going to make that if they're funding me for my election. So that's why I don't think judges should be elected.
Okay, well, unfortunately, I think that's it. And maybe you have any final comments? Does anybody have a final question? Did you have a question?
Yes.
What was it?
Have you ever lost sleep over a verdict before you sentence someone?
All the time. All the time. I mean, we're all human and no one wants to send someone to jail.
Yeah. Here. Okay, last question. Okay, well, I want to thank Justice Barnes and Magistrate Brady.
Please take a visit to the Malden Courthouse. You're all welcome. If you want to come as a class or as a group, we'll welcome you in. Like I said, it's always better to come through the front door.
I'd like, just on behalf of the students here, we have just have a small little token of I really want to thank for taking, I mean, the court system is busy. They've been mentioned about the court, Your Honor. I have to say, the clerks, the staff, the judges in Massachusetts are outstanding. I've never had a situation where, you know, in talking with other members of the bar, that say that this judge is just off the wall. I mean, if we lose, of course, we're not too happy, but, you know, I have to say that the judges in Massachusetts are outstanding. So we thank you very much because today they're very busy, and to take an hour, even an hour out of the day is quite significant. They're going to work double time when they get back to the court.
I just wanted to say to you also, if you're unsure about which direction you want to go with your career, and you ever wanted to come and just see what we do and learn a little bit about it, or do an internship, I'm always open to that, and it might help you in your future applications for college or a job down the road. So please feel free to reach out.
Thank you.